please take your seats.
Caribbean Court of Justice, Appellate Jurisdiction, hearing of an application for special leave to appeal, CCJ application number GYCR2019 between Linton Pompey and the Director of Public Prosecutions. May we have the appearances, please?
May it please Your Honors, I appear for the applicant.
May it please Your Honors, Shannon Lake and Natasha Baka on behalf of the respondent.
Good morning, and thank you, Counsel. We are prepared to hear your application. Mr. Hughes, was it?
Sorry, yes, Mr. Nigel Hughes for the applicant. Your Honors, I wonder if you would permit me to commence by apologizing for some confusion in relation to two sets of submissions that you've received from the applicant. I am only relying on the submission set out between pages 254 to 263, entitled "The Applicant's Reply to Respondent's Submissions," and not the second set that was inadvertently posted, between 266 and 271.
Very well.
In relation to the ones that I am relying on, Your Honor, I want to apologize for some typographical errors that appeared during the course of that submission. I personally was not there, but I accept full responsibility for them and ask that you forgive them.
Forgiveness extended.
Thank you, sir. There's nothing that I particularly want to add. I think the application is limited to two very narrow points, well, not necessarily narrow, but to 2 points. One in which Her Honor, we feel, fell into error insofar as the manner in which the defense of the accused was treated with, and the other ground is on sentence. Both of which we have set out in those submissions, and unless Your Honors are of the view that we could be of further assistance, we would rely on those submissions, Your Honor.
Mr. Hughes, you are saying you don't wish to elaborate at all on any of the written submissions you have presented to us?
No, Your Honor. Perhaps only insofar as sentence is concerned. I think Your Honors are aware that there are no guidelines in Guyana. My learned friend on the other side referred to guidelines that were contained in, I believe, Archbold. But those are guidelines that I believe are not applicable or could be relied upon here in Guyana, in which case we fall back on the common law. And in relation to reliance on the common law, I believe that the principles for sentence certainly were not pursued or addressed, or there's no indication that Her Honor addressed those at the time of sentence and on the imposition of the consecutive sentences. And in addition to, there's not much more than that we wish to say because we believe that on that issue particularly, the requirements we respectfully submit at this stage have been met.
If I may say, having read the submissions, we were of the view that you might want to persuade us, particularly on the first issue, that is to do with the conviction. We're not pressing you, of course, so if you don't wish to add anything further, that is fine, and we appreciate that. But I'm just saying to you that that first limb was one on which we thought that you might have been able to help us.
Your Honor,
If I may, Mr. Hughes, if I may add to what the President has indicated, for my own part, I thought that the submissions on both sides were very ample, and of course, as the President indicated, you may wish to seek further to persuade us, but for my own part, I want to say that I'm quite...
Thank you, Your Honor.
No, let me finish. I'm quite satisfied with the completeness of your submission, so I don't think you should think that there is anything the President is suggesting that there's any gap. That's all I'm saying.
I am thankful to Your Honor for that. If Your Honors don't mind, I will accept the invitation. What I will, so that we're not distracted, what I will say is that the convictions on count number 1 and count number 3 are not particularly disputed, or I should say not being pursued with any degree of vigor, because the grounds upon which we rely are for the incident that took place on in January, and not the 2 previous ones. So the 2 previous counts of sexual activity with a child and the rape are not ones that we are necessarily pursuing with any degree of vigor. On the 3rd count, which is the one that we believe that Her Honor fell into significant error, what I would like to invite Your Honors to consider is the fact that Her Honor, in her summation to the jury, literally, first of all, did not refer to the testimony of the defense witness, but perhaps one can forgive that. It is the impact of the absence of any attention to that testimony is the basis upon which I believe the accused person fell into considerable jeopardy, and as a result, I believe a miscarriage of justice occurred. Because Her Honor miscategorized the testimony of that witness insofar as she sought to attribute its significance, only to the question of noise, rather than to the fact that the witness on the cross-examination specifically said, when cross-examined by the prosecutor about the location of the accused at the time, she said he definitely was not in the kitchen, he was outside. So that was a complete defense if the jury were appropriately assisted in addressing that. The time spent by the learned trial judge and the detailed attention paid by the learned trial judge to every aspect of the prosecution's case, and the fact that her only reference to the testimony of the defense witness was merely in passing when dealing with the prosecution's case, I think created and could have created the impression in the jury's mind either that testimony was not important by its non-mention by the learned trial judge, or that little attention ought to have been paid to it. And in those circumstances, Your Honor, I believe that that flaw, despite the fact that in her general summation dealing with the principles applicable to criminal law, did say that she may not mention matters, I think that there was severe prejudice to the accused in the conduct of that aspect of the trial. And therefore, when the learned, the honors of the Court of Appeal felt that there was sufficient evidence based on the 2 previous counts that the verdict would not have been affected, I believe their honors fell into error because they were proceeding to consider and weigh aspects of fact which were solely within the purview of the learned trial of the jury.
Mr. Hughes, may I ask you a question? On what is the basis for your criticism of the Court of Appeal's reasoning?
Well,
you've just said to us that the Court of Appeal did certain things and did not do certain things. What is the basis of that review? Something you heard or read? Because we have no reasons from the Court of Appeal or no transcript of the Court of Appeal's reasons.
Indeed, Your Honor, I was going to point that out, that whatever I say is subject to difficulty or disability we suffer of not having the written decision, unanimous decision of the court. So the basis upon sought to appeals ruling was based purely on my presence and not on official record. We have inquired repeatedly about it, and we have unfortunately not received it.
So you have in fact written, making requests for these reasons since the decision?
Indeed, Your Honor. As a matter of fact, those requests,
And
sorry.
And is it that you have never received a reply or response? Or have you received responses undertaken to give it and it's not been given? What's the status?
Your Honor, we have received oral responses on at least 3 occasions of its unavailability and the fact that it is being attended to.
I see. Attended to meaning that they were attempting or undertaking to provide them at some point in time?
Your Honor, without seeking to...
You see, I don't have sight of your letters making the requests or the responses from the registry in Guyana, whether through under the hand of the registrar or otherwise. I must say, for me, it is a matter of concern that this is a criticism by you and a support by the other side of a decision of a court which makes an assumption that at least the two of you know what was decided, but more importantly, why. What was considered and what was not considered, basically reasons.
Your Honor, what I can say to you with certainty is that I personally have inquired from Mr. Kemarach at the Court of Appeal here in Guyana orally about the availability of the record on at least 3 or 4 occasions. As a matter of fact, whenever I come up for other matters, and as recently as the commencement of this week, that decision was not available, and I was informed that it was being attended to. I regret that I can't provide you with further detail other than that. And certainly in terms of the written request, I can certainly have that made available to the court. I can't do that now because I didn't bring it, but I can certainly have that made available to the court.
Okay, thank you.
Is there anything further, Mr. Hughes?
No, Your Honor.
So just to be clear, you are not pressing, just to quote your words, with any vigor, the grounds you advanced in relation to 2 counts. Your concern relates at this point to the count relative to the incident which was alleged to have occurred in the kitchen.
Indeed, Your Honor, and also the question of sentence across the board.
Yes, no, that's a second issue, but yes, in relation to the conviction. All right, but at the same time, just to be clear, your client is not admitting that he committed these offenses.
No.
Wonderful.
He's not admitting at all. I was just...
Yes.
Sorry, and I really just didn't want to consume judicial time.
No. I just wanted to be clear because obviously that issue could be relevant to the second. So I just wanted to be clear of the position of your client that he maintains his innocence in relation to all 3 counts. Thank you very much. Yes. 1 second, counsel, please.
We should have a few button notes. You love it too. I have a lovely transcript. When I asked me, I have a lovely transcript. I asked.
Is it Ms. Lake?
Yes, please, Your Honor.
Yes, please.
Your Honor, before I commence, just like to indicate to the court that we had requested a transcript, the oral transcript from the Registrar of the Supreme Court, the Court Reporting Unit, and it was provided to us. However, we were not aware that the oral transcript was not provided to the court.
Right.
So, if the
Ms.
court
Lake, just a
wishes-
minute. Can you just repeat? Are you saying that you are in fact in possession of the oral transcript of the decision of the Court of Appeal?
Yes, please, Your Honor.
I see. And may I ask, why was that never included or in the record of appeal? I know you don't have conduct of that, but at a case management conference before today, did you ever disclose that you had that?
We received it after we would have submitted the affidavit in opposition, so it was, I did not walk with the letter today, but we received it just before we would have put in submissions, please, Your Honor.
All right.
So it would not have formed part of the bundle because we could not have attached it to the affidavit, please, Your Honor.
So, but Councillor, if I may follow on from that, is Mr. Hughes aware that you have this?
No.
No?
No.
So the
I
Hughes,
just informed him when I realized he was saying that he asked and he did not get the transcript.
so this is news to you? You thought he had
Yes,
it?
it is, Your
No, Miss Counsel, State Counsel. As far as your thinking was that Mr. Hughes also had it, is that correct?
Yes, because
Okay.
I'm aware from other matters that normally it would be the other side that requests it and would share it.
Okay.
A previous matter, the other side was shared it with the court, please, Your Honor.
Okay.
Having seen it, can you say how long it is? How many pages?
It's 9 pages, well, 9 pages, please, Your Honor.
In total?
Yes, please. 10, bearing that the front page is just indicating what the document is.
Okay.
For the substance, 9 pages.
So we expect that what will take place is, just as you leave the courtroom, you will give Mr. Hughes your copy and get another copy, and this will enable Mr. Hughes to file that document as a supplement to the record.
No problem, please, Your Honor. I'll
Okay.
do that.
Thank you.
I wanted to ask another question, given the brevity, relative brevity of the transcript. Mr. Hughes, how much time do you think you would require to have a look at it and see whether it would make any difference to your application?
To be honest, my friend is on her legs now. I'm sure before the end of the day, I could probably reply. Because I was present when it was delivered. So only if there's some significant variance would I have a difficulty. So,
But how long would it take you to see, I'm sorry, how long would it take you to see if there is a significant variance?
10 minutes, Your Honor.
So if you were to adjourn for 10 minutes and come back, would you be able to then answer whether there's a significant variance?
Yes, indeed, Your Honor.
We'll adjourn for 15 minutes.
Thank you.
Justice.
Mr. Kachitz.
Mr. Hughes.
Sir, no variance. It is consistent with my recollection and my references. I just don't have the identical language, but no variance, Your Honor.
You are comforted.
I'm feeling no pain at this moment, Your Honor.
Thank you. Thank you, Mr. Hughes. So you may proceed, Ms. Lake.
Please, Your Honor. May it please Your Honors, this application...
Now, sorry, not to
arises-
interrupt. Sorry to interrupt. But remember, of course, that this is not the hearing of the appeal. This is the
Yes, Your
hearing
Honor.
of an application for leave to appeal. So, very succinct, please, yes.
Yes, please, Your Honor. Your Honor, as the court is aware, for special leave to be granted, the applicant must seek to invoke the court's discretionary power to grant leave to appeal, and there are certain tests or requirements which the applicant must reach in order to be able to cause Your Honors to exercise your discretions. And Your Honors, we have all the cases as noted in the written submission arising out of your court, please, Your Honor. What the respondent wishes to focus on this morning, please, Your Honors, is in relation to the ground that the applicant's defense was not fairly put by the learned trial judge.
Is that
On
the
this-
ground that Mr. Hughes is pursuing it bigger?
Yes, please, Your Honor.
Ah, I see. So let's address only that ground, if you don't mind.
Yes, please, Your Honor. On this issue, it is respectfully submitted that the applicant's defense was fairly put to the jury by the learned trial judge. The Court of Appeal found in their oral decision that the applicant's defense was placed before the jury at the beginning and during the summation, and the learned trial judge would have told the jury that the denial that the accused would have done after they would have had a family meeting concerning this incident meant that he did not do it, and that the jury should acquit him at the end of the matter once they believe him. Later on in the said summation, please, Your Honors, the learned trial judge, after speaking about some aspects of the defense case, again reminded the jury that the applicant was saying that he did not do it. And once they believed that the applicant did not do it, they were to acquit him. On that basis, please, Your Honor, it is a respectful submission that the applicant was not robbed of a chance of acquittal by the summation of the learned trial judge, and the Court of Appeal found that even though the learned trial judge should have mentioned some aspects of the defense witness case within the summation dealing with the defense case, the lack of it did not jeopardize the conviction of the accused of the applicant on the third count. And it is respectfully submitted, please, Your Honors, when you look at the decision of the learned trial judge at the judges at the Court of Appeal to uphold the conviction and sentence of the applicant, that the honors did not cause a miscarriage of justice, and that there was no error in law in them agreeing that the conviction and sentence of the accused was proper when they affirmed the sentence and the conviction, please, Your Honors. Your Honors, that is what, in addition to what is in the written submissions, that is what the respondent will submit on this issue.
Thank you.
Unless there is anything.
Did you want to say anything about the sentence? Are you
Yes,
opposing
please, Your Honor.
leave in relation to sentence as well?
Yes, please, Your Honor. It is the state's respectful submission and relying on Vishnu Rajal and Ardat Koshar, the decision from the CCJ also. At paragraph 33, it will be stated that consecutive sentences may also be imposed where the offenses are of the same or similar kind but where the overall criminality will not sufficiently be reflected by the concurrent sentences. Your Honors, under the Sexual Offences Act, the sentence for rape of a child under 16 is life imprisonment, and for sexual activity with a child is 10 years. For the offences of rape, the learning trial judge would have given 15 years, 17 years, and for the sexual activity with a child, 5 years, please, Your Honors. And it is respectfully submitted that when you look at the sentences given for each individual offense, that it was not manifestly excessive. And even when it is combined to form the 37-year sentence, it is respectfully submitted that that too is not manifestly excessive. And the Court of Appeal, when they were given their decision, stated that these type of matters are the matters that they must send a message and that they must sentence condignly. So it was respectfully submitted that when they would have upheld the 37-year sentence, this was not a miscarriage of justice, nor they are in law, please, Your Honors. Your Honors, that is the extent on this issue, in addition to what is in the written submissions.
Okay, thank you. Okay. All right, so can we then finalize when is it that we could be in receipt of the transcript of the Court of Appeals decision?
Your Honor, upon my receipt when we leave, when I depart today, as my friend I'm sure will share that with me, I will have it uploaded this afternoon.
This afternoon? Okay.
Well, my friend is indicating that it can be uploaded by her immediately. So, at the latest this afternoon by me or immediately by my friend.
Wonderful. Okay, thank you very much, Mr. Hughes.
Thank you.
In the circumstances where we do not have the transcript with us at present, the panel is not minded to give a decision on the application at this point. We will receive the transcript, review it along with the other submissions, both written and oral, and then give our decision. We don't anticipate that giving a decision will take a very long time, but we do want the opportunity to look at the transcript. Without showing our hand one way or the other, just to ask whether in the event we were to agree to give leave, that has not been decided, of course. But the question that we wanted to raise with you was whether the 21st of January 2020 might be an appropriate date for you to bear in mind. Is it Ms. Lake who is smiling?
Yes, please, Your Honor.
There's a special significance attached to that date, Ms. Lake?
No, please, Your Honor.
Okay, wonderful.
Your Honor, the 21st would not be inconvenient to the applicant.
Okay.
And my friend has indicated neither to the respondent.
Okay, all right. So we'll bear that in mind in the event that there was a decision to grant leave. And as to that decision, you will be informed pretty shortly.
Thank you.
Your Honor.
Thank you.
Court rise.